The Companies Act 1956. The Companies Act 1956. Today we are having preliminary information about Section 1 of the Companies Act 1956. Part 1, Preliminary. This Companies Act 1956 is an act to consolidate and amend the law relating to companies and certain other associations. Yes, it is an act to consolidate and amend the law relating to companies and certain other associations. We may understand what are these certain other associations. Be it enacted by Parliament in the 6th year of the Republic of India as follows. Part 1, Preliminary. Section 1 brings us short title, commencement and extent of the Companies Act 1956. This act may be called the Companies Act 1956. It shall come into force on such date as the central government may appoint. How does it appoint? It appoints by notification in the official gazette. Subsection 3 of Section 1, it extends to the whole of India. There is a proviso to subsection 3 of Section 1, provided that it shall apply to the state of Nagaland, subject to such modifications, if any, as the central government may specify. How? By notification in the official gazette. Let us have some more understanding about Section 1 of the Companies Act 1956. The Companies Act 1956. Many of us have much of insight about the corporate laws. It is not new to us, the term corporate laws. Yes, the Companies Act 1956 is very interesting among them. More than half a century old is this Companies Act 1956. As we are aware, we are in the year 2012. Yes, it is very long period, half a century old is this Companies Act 1956. How relevant is this act to us now in the year 2012? There are many developments. There are many changes in the corporate sector which we can't ignore. This corporate sector transforms in different directions, in different dimensions also. We need to mull over it. We need to consider all these changes. We need to change our approach to the corporate sector. The ever-changing business ground realities demand us to modify ourselves and move in the right direction. The changes in the corporate sector are so vast, so different, we could not envisage the day this act was enacted. Even the Parliament could not envisage those days. Even then, most of the act has stood the test of time. The act obviously We mean here the Companies Act 1956. Does it not felt the necessary amendments could be introduced to keep with the developments in the corporate sector? It is desperately realized year on year the impending changes required. It is also set to recodify this massive legislation. Yes, there are many amendments to this Companies Act 1956. It has been amended by many enactments since 1956. After this Companies Act 1956, which was come into force with effect from 1st April 1956. Prior to this Companies Act 1956, we are also aware there were some acts relating to companies in force in India. We may find those companies laws in clause 2 of subsection 1 of section 3. When we come across about understanding existing companies, let us go through what are those previous companies acts. Any act or acts relating to companies in force before the Indian Companies Act 1866 and repealed by that act. First, any acts or acts relating to companies in force before the Indian Companies Act 1866 and repealed by that act. Second, the Indian Companies Act 1866. Third, the Indian Companies Act 1882. Fourth, the Indian Companies Act 1913. Fifth, the Registration of Transferred Companies Ordinance 1942. Similar acts were there in India before the Companies Act 1956. Those acts were in force in India prior to this Companies Act 1956. You are right. It is an act of the central legislature. This doubt you may get on coming across expression earlier in the merged territories or in a Part B states. The situation was there before with different acts for different territories, different states identified under different parts like A, B in India. An act to consolidate and amend the law relating to companies and certain other associations is an expression we first come across in the Companies Act 1956. The first sentence we read, that is repeat, an act to consolidate and amend the law relating to companies and certain other associations. Is it an act to consolidate or is it an act to amend? Both. It is an act to consolidate and also it is an act to amend. Consolidate and amend what? What is it going to consolidate? What is it going to amend? The law relating to companies and also certain other associations. It is an act to consolidate and amend the laws relating to companies and certain other associations. We need to conclude these laws which we come across. All those acts relating to companies in force before this Act 1956 in India, here and there, with some inevitable amendments, the very sections of the previous acts are basically reproduced on the one side, and on the other side there are some amendments which are significant. It is essential to consolidate and amend the law whenever it is necessary. Let us move to the subject. Be it enacted by Parliament in the 6th year of the Republic of India as follows. This is second sentence we find in the Companies Act 1956. Let us go to subsection 1 of section 1. This act may be called the Companies Act 1956. Here we need to remember that this act received the assent of the then President of India on January 18, 1956. When did the assent this act receive? It was on January 18, 1956. Let us go to subsection 2 of section 1 of the Companies Act 1956. Here, it shall come into force on such a date as central government may appoint by notification in the official gazette. Right. This Companies Act 1956 come into force on April 1st, 1956. Why notification number SRO 612 dated March 3rd, 1956. Yes, this act come into force on April 1st, 1956. Recollect that this is an act to consolidate and amend the law relating to companies and certain other associations. It is an act that is both consolidating and amending. Again, let us remember, it is both consolidating and amending the act. Let us go to subsection 3 of section 1. It says, this act extends to the whole of India. It carries a proviso, provided that it shall apply to the state of Nagaland, subject to such modifications, if any, as central government may specify by notification in the official gazette. Subsection 3 says, this Companies Act 1956 extends to the whole of India, provided that it shall apply to the state of Nagaland to such modification, subject to such modifications as central government may specify by notification in the official gazette. Yes, it extends to the whole of India. Underline the expression whole of India. Why is it said as whole of India? Because there were different territories having different acts in India. Similarly, different states were having different acts in India. Some acts were applying a group of states. It was so those days before this Companies Act 1956 come into force. The Companies Act 1956, yes, again let us remember, it extends to the whole of India. There is a proviso to this subsection 3 of the section 1. This proviso was inserted by the Act 31 of 1965 with effect from October 15, 1965. A couple of minutes back, we come across an expression that it is an act of the central legislature. It is an act of the central legislature. Let us understand something about what is central legislature. The entries 43 and 44 in the list 1 means the union list. List 1 means, or list 1 stands for union list. In the 7th schedule of the Constitution, it is our Indian Constitution, the Companies Act is an act of the central legislature. Again, the entries 43 and 44 in the list 1 means union list. In the 7th schedule of the Constitution, the Companies Act is an act of the central legislature. You all are aware that there are two lists. One you already come across, that is union list, just a couple of seconds back, and another is state list. It implies to all trading corporations, and in the case of non-trading corporations, those whose objects extend to more than one state, central legislature applies. The only companies that don't come into within the scope of the act, or within the scope of this act, are those corporations other than trading companies whose objects are confined to one state, like cooperative societies, whose operations are objects confined to one state, universities, whose objects are confined to one state, trading corporations which are unincorporated, whose objects are confined to one state, and scientific and other societies and associations which may find in item 32 of the state list in the 7th schedule of the Constitution. Here we focus our attention on understanding what is central legislature and what comes under the union list and the state list, as both are come under the Constitution of India. Let us recollect again that this act extends to the whole of India, provided that it shall apply to the state of Nagaland, subject to such modifications as the central government may specify by notification in the official gazette. Subject to such modifications, if any, by notifications in the official gazette. Here, let us try to understand a bit more. The language of the act is very interesting. The words in the statute are very interesting, which require our attention every time we recollect, as they may lead to anomalous results many times. Again, the language of the act is very interesting. The words in the statute are also very interesting, which require our attention every time we recollect, as they may lead to anomalous results many times. Yes, anomalous results, which may not be with the real intention of the act. Anomalous results, which may not be with the real intention of the act. What happens in such situations? It is left to the courts to depart from plain meanings. It is justified in following to do. There are 4 points. Let us go through. The courts are expected to depart from plain meanings. Let us go through. Number one, that there is clear and gross case of anomaly. Second, that such an anomaly could not be envisaged by the Parliament. Third, that the anomaly can be obviated or removed without detriment to the legislative objective. And fourth, that the language of the statute is susceptible, very likely to be influenced of the modifications required to obviate the anomaly. May we repeat these 4 points where the court can depart from plain meanings. Let us see. First, that there is a clear and gross case of anomaly. Second, that such anomaly could not be envisaged. Second, that such an anomaly could not be envisaged by the Parliament. Third, that the anomaly can be obviated without detriment. That the anomaly can be removed without detriment, without causing harm or without causing damage to the legislative objective. Fourth, that the language of the statute is very influencing. If the language of the statute is susceptible of the modifications required to obviate the anomaly. Again, recollect that the Companies Act 1956. This act consists of 13 parts carrying 750 plus sections and 15 schedules. Let us recollect first. The Companies Act 1956. It is an act to consolidate and amend the law relating to companies and certain other associations, be it enacted by Parliament in the 6th year of the Republic of India as follows. Section 1 of the Companies Act 1956, it comes in Part 1 Preliminary. Subsection 1 of Section 1 says, this Act may be called the Companies Act 1956. Subsection 2 of Section 1 says, it shall come into force on such a date as the central government may appoint by notification in the official gazette. It extends to the whole of India, provided that it shall apply to the state of Nagaland, subject to such modifications as the central government may by notification in the official gazette specify. Let us have a bit more understanding. This act may be called the Companies Act 1956. Here we need to remember that this act received the assent of the then President of India on January 18, 1956. Subsection 2 of Section 1, it shall come into force on such date as central government may appoint by notification in the official gazette? Yes, it came into force on 1st April 1956. While it was notified, SRO 612 dated March 3, 1956. Third, it extends to the whole of India, provided that it shall apply to the state of Nagaland, subject to such modifications as the central government may, by notification in the official gazette, specify. Here, we are able to complete Section 1 of the Companies Act 1956 and try to understand the provisions of subsection Section 1, which is having three subsections 1, 2, and 3. Thank you, all of you.